softer and gentler, so I have to make a very special effort to be heard.
Well,
if you
we're
don't
happy
mind.
for that.
Yes, ma'am.
Yes, Mr. Fletcher.
So I appear, and with me is Mr. Russell Stewart, who sits behind me there.
Stewart with a W or U?
A W. The learned director of public prosecution leads the prosecution team.
That's still Miss Paula Llewellyn.
Miss Paula V. Vanessa Llewellyn.
KC.
Casey.
King's Counsel.
King's
Thank you.
Counsel. And with her is Miss Julianne Edwards.
Is it Miss, Ms?
That is what I see on the document.
MS or MISS?
I see MISS.
Thank you. Miss
Julianne.
Spell that for us, please.
JUDI-ANN. And
Edwards.
Edwards, Assistant Director of Public Prosecutions. And Lorianne, L-O-R-I-A-N-N, no hyphen.
Miss, Ms.
Ms. M-S, M-I-S-S.
Thank you.
Togwell, Crown Counsel.
She's there.
She was here. I think she has gone on an errand
Yes.
relating to the matter. And the Attorney General's Department is represented here by Mr. Jeffrey Foreman.
Mr.
Jeffrey Foreman.
Spell the Jeffrey for us.
Jeffrey.
Yes. Foreman.
Foreman.
Yes.
Senior Assistant Attorney General.
Yes.
Yes.
So we would have the DPP's office as the respondents. So they're the respondents. And the AG is as friend of the court. We invited them in.
Yes.
Yes. Yes, Mr. Fletcher, administrative housekeeping now
Yes, ma'am.
as to what we should have for the hearing. Bundles?
There is a submissions and skeleton arguments.
Sorry. Yes, my brother has asked me to ascertain if we should have Mr. Foreman instructed by the Director of State Proceedings. Thank you. Very well, thank you. Before you tell us anything about the bundles, Mr. Fletcher, we know that on Friday we received what are called further submissions from the Office of the Director of Public Prosecutions. I do not know how those happened to come on Friday, since we had given deadlines for all matters, all submissions to be filed before then, and whether those will be relied on. And your position on that.
Well, may I yield to my friend?
1 second, please. I'm not even sure if we have received hard copies, just the electronic copies. No. Yes, Mr. Fletcher, with that said, you're on your feet.
With that said, ma'am, may I ask your permission to just yield to my friend?
Yes.
Yes.
May it please you, Lady President, first of all, let me apologize for the fact that we had to file those further submissions on Friday. But what happened was that I was in the Portland circuit in the middle of a murder case, and it was only on Wednesday that this matter came to my direct attention. And having recognized the critical importance of it, I thought that the DPP, once I'm available, should really lead the prosecutor's team in this matter. Having had consultations with Ms. Thompson and my two juniors in the matter, and become aware of the issues, and having read our submissions that had been previously filed, I took the view, as a matter of law, that we should go in another direction. And so that I would not
So they are
have
not.
the
Oh, sorry.
court taken by surprise, we decided, in an abundance of caution, to file those further submissions.
You call them further, though, and
Well,
upon our reading, they are really not further. They
Very
seem to be
well.
completely new
Well, they are
submissions,
new submissions.
which would mean you would not be standing on the ones that were previously
That is
filed.
so. That is so.
So
my
that
lady.
should have been indicated to us, and it depends on whether you're taking the other side by surprise, because that's a matter for your office, of course, how you saw it fit to deploy your case in response. But the court had already fixed the deadlines, as you'd appreciate. So if the applicant would be prejudiced, then that's a matter we have to look at.
Well, my lady,
So
I
Mr.
can-
Fletcher
I
will
can
have to
understand
advise
that,
how he
but
takes that one.
I would only seek to explain, and in any event, Ms. Thompson, who had filed the original submissions when she was acting in my stead, is also involved in a murder case in the Home Circuit Court. So, having apprised myself, though
That's
it was
Friday
by
evening,
phone,
though.
Mel-
That was Friday.
That is so, and we have just been able over the weekend to put the hard copy together, which is being filed now. But it's a situation, my lady, that I really was not aware of the matter until Wednesday. And it would have been remiss of me to see the critical importance of the matter and having more experience looking at it to not appear in the matter.
Well, we
myself.
welcome your appearance, but as I said, in terms of how you deploy your case, that's really a matter for you and your department. It's just that the court will not be inconvenienced by any late filing. It's a matter for my colleagues as well, and how it will impact the hearing of the matter. Up to now, we are not in receipt of the hard copies, which again complicate things.
Well, my lady,
The only good thing is that we got it
got it
electronically, and we gave that credit to
but
you.
not that we are making an excuse. Your ladyship would know that we have some measure of dislocation in terms of our headquarters, but nonetheless, we were able to pivot
Alright.
by Friday evening late, but by that time, it was too late to file the hard copies. But we have them ready, and we offer them so that when I come to speak,
Very well.
you would be able to follow. And even with that, I will just signify that we have also found two other authorities just over the weekend. My lady, it is really only the weekend that I myself have had sight of all the hard copies in this matter.
This is what we try to guard against and
That
to
is so, my
prevent
lady.
papers coming up to us
My
on
lady,
the morning
I
of
think
court.
the office of the DPP has acquitted itself pretty well in obeying the rules, but it's just that I really was not here, and I only knew about it this week. And I was in the middle of a murder case out of the jurisdiction.
Thank you,
So
madam.
I'm seeking only to assist the court, but the exigencies have really caused a state of affairs, and for that, I offer an apology and regret. May it please you.
Thank you. Mr. Fletcher, ball is in your court. You're the one most likely to be prejudiced by late service.
I think the court is sensitive to the type of prejudice that might be caused by late service. Of course, I'm always in the court's hands, as you know. But I'll have to be processing that which is served on me now.
Well, put it this way, we wouldn't put you under that strain to process anything at this point, given what Madam DPP has said. It is no excuse, and the court has not excused it. The only reason why we'll permit it is because of the import, the significance of the case, and the fact that the court would need all the assistance it can get with ventilation of the issue. So the most we could do to ensure that you're not prejudiced is to permit you time after your submissions because we cannot waste time to rise and permit you to do that now. But it's their response, and you have a right to reply in any event.
Yes.
So you'll be given time to do that.
Yes.
And it would be to their authorities and anything new that they seek to put before us that you would not have known about. So it would really be a matter of you replying to them,
Yes.
and we'll give you sufficient time to prepare that reply.
Yes.
Because in the ordinary course of things, that is what would have happened.
Yes, my lady.
Anyway.
Because in fact, the DPP's position has changed
Yes.
since the first
We see.
response that we had. And naturally, the panel would expect us to begin a recalibration of our approach, even to our first submission here.
Not getting you, because you would have submitted before you received the first set of submissions, and your case would not change based on your submissions there until you are ready to reply. So I'm not understanding you. You would have filed your submissions before receipt of their original submissions.
You're correct, President.
Yes.
I'm not saying that I would like to deal with that. No, you are right. In reply, as long as I would be given the opportunity to reply not only to cases raised, but to the approach.
But
of
I
the
said
change.
anything else that you see fit in
Very
terms
well.
of what is new before you.
Very well.
But, yes, but the thing is that you can get the time, which is what would take care of any issue of likely prejudice.
Yes, ma'am.
But you just have to deploy your case as you have initially planned to deploy it, acting as if the DPP has not responded to you.
Yes, ma'am.
And then after you look at their response, then you have the right to reply,
Thank you very much.
subject to the court's guidance.
Thank you very much.
So we are now ready as to what the bundles are that we should have and the papers that we should have, so we can put aside what we don't need.
Yes, ma'am.
So help us out now. The ground document would be the transcript. Mr. Fletcher,
Yes, ma'am. The transcript.
the foundation document is a transcript, which you can call the transcript. Yeah, the next bundle now.
Is-
Okay. All right, what are you calling now? Respond. Which one is it?
Just my name, where it has the score bundle.
What it looks like, please. What's the heading? What's the title?
Index to judges bundle of authorities on documents. That's
Yes,
one.
that's what we call. Okay,
Yes.
very well. Volume 1 then.
Yes, ma'am.
So we refer to this as volume 1 for convenience.
Thank you, ma'am. Yes, yes.
And we call the transcript, right? Yes, next one.
And may, if you will allow me, that does contain the case management orders.
Yes. We see that.
the original supplementary grounds and skeleton arguments being that which came before the court when the matter came up first.
Yes.
Yes.
Well, you have changed that?
No, ma'am, that's the past.
Okay.
And a range of cases thereafter.
Those are your authorities?
Yes.
Yes. What you say original supplementary grounds, do we have further supplementary grounds? Or additional?
Where is that? Just a minute.
This is what? Attorney General.
That was the ones filed in pursuance of the case management orders. Written submissions
Okay.
in compliance with case management directions.
File December 9.
Yes,
So
Madam
that
President.
goes with 1. So that would be probably 2.
Yes, ma'am.
Yes.
So I will not mention, and I seek your guidance on this, the first response by the DPP. It is no longer active.
Let them tell you.
Yes,
Unless they're relying on the authorities.
in the bundle, yes.
Sorry, unless
The
they're
authorities
relying
in
on
the
the
bundle.
authorities. So is the submissions, which is
The
tab
submission,
A,
the
that would
submission.
not be relevant?
That is right, ma'am.
So we would, and we don't, do we now have the hard copies of their submissions? Are they ready? I saw some papers came in, I'm not sure. This is it? Very well, so what we'll do is just put this as part of what we would call now volume 3. So we start to take out the, just know that tab A as it stands is not applicable to the hearing or relevant, but we will substitute what are called the further submissions.
Further submission. Just
This is volume 3.
volume 3.
That's in.
Are you right?
And there's an additional authority to go have a look at this thing.
Where is that? That is coming, that authority. 2 more authorities. So there are 2 more authorities to come, I'm told.
Yes. So we call the DPP's documents volume 3.
Yes, ma'am.
We just put everything belonging to them.
And just as a
In
matter
that.
just as a matter of tidiness and record, may I just say that that new submissions by the DPP was sent by email to me Friday evening.
I suspected so.
Yes.
Thank you. And then now we have the Attorney General's submissions and bundle of authorities.
And bundle of authority.
So we would put the submissions of the Attorney General's chambers in this bundle and call it volume 4.
Volume 4.
Volume 4 submissions, and so they can refer to the submissions. Volume 4. That's it then?
Yes.
So we should have 4 bundles
4
with documents attached.
documents attached.
Oh. Mr. James, give this to just I should say before we commence that the court takes a break after 1 hour. That's part of our wellness break so that we can be refreshed, their spine. And we invite counsel to do the same and everyone else sitting in the courtroom. So at 10:30, we will rise for 10 minutes. Thank you. Yes, Mr. Fletcher. Bearing in mind that you have law students, you can give us a broad overview of the case, and then you condescend to the particulars.
Yes,
Which bundle do we need first? It would be volume 1.
volume 1.
And I suspect the transcript, I don't know.
Won't be necessary.
Okay, thank you.
Members of the panel, I start with a brief but relevant aside that this matter actually began as a matter that our learned and late departed friend, Miss Nancy Andis, had as a legal aid matter. And then she died, of course.
Regrettably, yes.
To our regret. And the council asked Mr. Russell Stewart to take it on. And he asked me.
Yes.
And that is how, in fact, it came before the court for the first time as an application to get time spent in remand credited. It is on that occasion that the court signaled and posed, indicated that the court might want a wider discussion
Yes.
of this principle and set the matter for today. Your Ladyship made extensive case management orders, and they are found in Volume 1, Tab 1.
Yes.
And if the court would just allow me to, because I think it will be useful to refer to it, because at order number 5 is where the crux of the matter is adumbrated. It reads that the Attorney General, for which purposes I include myself, bearing in mind what's worded, the Attorney General is invited to make written and oral submissions on whether the applicant is to be given credit for time served in pre-trial custody in recognition of his constitutional right to liberty, notwithstanding the mandatory minimum sentence for wounding with intent under Section 20C of the Offences Against the Persons Act. That is the substance of our remit here today, and everything else is attendant on that. Mr. Moore had been sentenced on the
Could you start, just give us the backdrop before the sentence, as I've told you, just a broad overview
Yes,
as to what led us here.
yes.
He was charged, I suppose,
He was
initially.
charged.
So start from there, please.
Yes. He was charged with illegal possession of firearm and wounding with intent. The allegations against him were that he knew the complainant.
But the offense committed when? That would assist.
Yes, ma'am. And on June 17, 2012, he shot at the complainant multiple times. Whilst on his farm at approximately 8 o'clock in the morning. The complainant ran for his life, and the appellant gave chase. And he caught the complainant, and both lost their footing on the brink of a gully and slid into the gully. And there the complainant chopped the appellant with a machete, subdued the appellant, and escaped.
He's still the applicant, though.
Applicant. The applicant gave sworn evidence. He denied the allegations, asserted that even though he was present on the scene, it was the complainant who was hiding behind a mango tree, ambushed him, and chopped him in the face with a machete. And there's another part of the story. Masked man appears with gun in hand, and that masked man discharged the gun twice. And it appears, yes, discharged the gun twice away from the applicant, and then the complainant, along with the masked man, left the applicant on the ground. Then the complainant, along with the masked man who is said to have appeared, left the applicant on the ground. There, the issues having been joined, the matter was tried on the dates of March 7, 8, 9, and 10 of 2016. Conviction. He was convicted then in the first trial. Conviction. He was convicted then in the first trial. Yes. Yes. An order for retrial was made on the 19th of December, 2014.
His conviction would have been quashed and the sentence set aside.
And the sentence set aside and an order made for retrial.
When was that again, sorry?
The order, my lady,
Yes.
made on the
2014.
19th of December, 2014.
So he would have been in custody up to then.
Yes, ma'am, he was still in custody.
Yes.
Then on March 7th, 8th, 9th, and 10, 2016, the retrial took place in the Port Antonio, in the Portland Circuit. Charge of count 1, illegal possession of firearm. 2 counts and count 2 wounding with intent. He was found guilty on both counts and was sentenced to 8 years imprisonment for the illegal possession of firearm and 15 years imprisonment at hard labor for the wounding with intent. Both sentences to run concurrently.
Yes. 1 second, please. Yes. So he was sentenced on the retrial in 2016. So the question, since we are dealing with time spent on remand,
Yes, ma'am.
we have established that he was in custody up to when the Court of Appeal quashed the conviction
Yes, ma'am.
and set aside the sentence. So he remained in custody until the trial, or he was granted bail at some point. The second,
You have to come over here, sir.
because, yes, you should put him beside you,
Yes, ma'am.
Mr. Fletcher.
I'm asking him to.
Because I think when I looked at the transcript, I saw somewhere where he was on bail and the judge remanded him for like the afternoon, but extended the bail.
Yes.
But what we're not seeing on the record is when you would have gotten bail during the retrial.
If you could just give me a
Yes.
few seconds. What is the position? Is on bail out? You got bail on what happened?
I see you have 2 years and 9 months, so that's what we
Yes.
need to get clear.
And he was remanded again. He was on bail. But it's before that, the 2 years and 9 months, he was in custody. Yes.
DPP should have the record. I don't know if they have the
Well-
record. I see Miss Tugwell showing you
Well,
something.
Of my own. Yes. My lady, if you look
When
in,
did he get bail?
if you look in number 1, you will see the affidavit of the prosecution at tab 4. Because that question did arise at the appeal and it was researched.
Tab 4?
Yes, my lady. My learned
you-
friend.
Tab 4 of volume 1.
Wait, where is it? Yes.
Paragraph.
Where is it? Affidavit of Andre Wedderburn. Hold on, man. Paragraph 7 says,
Why the bail extended?
may I read it, ma'am? May I read it?
Yes.
That on July 12, 2012, the matter first came before the Portland Circuit and the applicant was remanded on July 13, 2012. The applicant was remanded after appearing in court, and on November the 28th, the trial commenced and the applicant was remanded. On November the 28th. On November the 29th, the applicant was found guilty for illegal possession of firearm and wounding with intent. And on December 17, 2012, he was sentenced.
Yes, that is, yeah, we are clear on that he was not given any bail during the first trial, and he was convicted, sent to, well, it would appear from the transcript, his lawyer said to the Tower Street Adult Correctional Center, that means
Yes, sir.
GP.
GP.
And his appeal was heard, and then I see paragraph 8 on December 18, 2014, he was brought back before the court in chambers where he was offered bail.
Yes.
So he was offered bail. He took up the bail when?
In March 10,
March
2015. And that is at paragraph 9 of the affidavit.
So he would have been in custody from July 12, 2012, or maybe before, because he would have been detained before he
So,
was
in
brought
fact,
to court. June what?
2012.
June 2012.
Yes. Arrest
Yes, to March 2015.
to March 2015.
And then he was taken back in custody on the completion of the second trial
That is right.
or before sentencing.
Hold on. Yes, I know. The second trial. My friend instructs me that he was actually on bail throughout the second trial. And that bail ended upon the conviction, of course.
On conviction.
On conviction.
I think he was sentenced the same day anyway.
Yes.
Wasn't he? Yes.
Yes.
All right, so we are clear now that he spent time in
Yeah.
custody.
We will adjust ourselves.
So now, he went before, he was convicted, second trial, and sentenced to the 15 years. And you'd want us to know that the 15 years would have been the statutory minimum for the offense of wounding with intent. So what happened at the sentencing now? Because you're not taking issue with his conviction.
No, ma'am.
Right.
The
Did he, 1 second,
No,
please. Give me 1 second, please. We're just checking your grounds, Mr. Fletcher, to see if when you file your supplementary, whether you have withdrawn your conviction application. I'm just not remembering. What page is that again? Tab 2. Because remember, yes, you have your original grounds, which we call the holding grounds from the prison, Mr. Fletcher.
Yes, ma'am.
In his form B1,
Yes, ma'am.
he has his grounds as unfair trial, etc.
Yes.
So he was challenging his conviction.
Yes, ma'am.
But then you say you will seek the court's permission to abandon these grounds. So I suppose we'll get there.
I did that. No.
No, but he has it in.
My
In the
learned-
B1, he didn't raise sentence. My sister showed.
My learned friend tells me that I did make that application to abandon those grounds
Yes.
and substitute the grounds filed,
Yes.
as is almost perfunctorily and normally done.
So you have the application itself that was made. It's a tab where? Because we're just looking at the skeleton arguments, and you say you will seek the court's permission.
Tab 2. Tab 2, my lady.
Where there?
That's the original supplementary grounds and skeleton arguments brought before the court.
And you were granted permission from that time before
Yes.
the other panel?
Yes, yes.
I see.
Yes, yes.
Very well.
Yes, my lady.
So the grounds that you'd be looking at would be...
Well,
So you practically would not be pursuing conviction from your
No, ma'am.
supplemental grounds. Okay,
No.
very well. All right, so let us hear what the judge did at the sentencing hearing, since conviction is not on the table.
Yes, ma'am. In that same document, what is it, tab 2? What is it, number 2? Our index of judges' bundles of authority and documents, ma'am. We quote at paragraph 5 the judge's sentencing. Remarks.
But, sorry, before you go there, just help us first to put on the table what was put before the judge by counsel, by reference to the transcript. Counsel for the applicant.
Come, talk up. Give me.
What page?
I'm coming, please. 1-4.
Okay, it's very short. Clean mitigation at page 147. Thanks.
Right.
Have you found it, Mr. We are
Yes,
there,
yes,
147.
yes, says.
He said, he did. It is significant to take into account, my lord, that the accused man did suffer serious injury to himself,
Yes.
did spend some time in the Tower Street
Correctional
Center.
This
This
being
being a retrial of the matter. And he has children and so on. He's a
3
man
children.
of some. Yes.
One of whom is just on the verge of.
And he doesn't believe that rehabilitation is gone. So it was noted that he spent time, but no one didn't investigate
Yes.
how much time he would have spent in the
Yes.
ordinary, which would have been in the ordinary course
Of things.
of things.
Yes.
But the judge did say, the lawyer did point out that he was at Tower Street
Yes.
for some time.
It wasn't expanded.
And this was a retrial.
Yes. The details weren't also offered. At the sentencing remarks,
Yes.
please stand. I've heard all of what your attorney has to say on your behalf. I do bear in mind, however, I do bear that in mind. However, you should understand that with respect to one of those offenses, the second offense, count 2, wounding with intent with an illegal firearm, the sentence is a 15-year sentence. It's the minimum set by law. I therefore cannot go below that sentence. So in showing some mercy, I will not go higher than that sentence. It appears that you were lay waiting
Do we have
the man with the intention to kill the man, etc.
Yeah.
So the sentencing remarks were also equally scant and brief and summary and efficient. Yes.
A lot of efficiency in this case, because remember, it was tried within about 3 months of coming in before the court.
Yes, ma'am.
2012.
Yes, ma'am.
Wish we could do all cases like that. Very well.
You know, Madam President, a long time ago, when I was very young counsel, when the DPP mentioned earlier that she knew me from my hair was black, I appeared before the Court of Appeal and Justice Fort was presiding. And at that time, whenever they dismissed an appeal, they made the sentence start 3 months after the conviction. I was bold enough at the time. I remember the trepidation I felt when I asked the question of the court, why 3 months? I do not remember which judge answered, but I know that it was said that in an ideal system, it would take 3 months for this matter to come before the court. Now, how
Wow.
ideal was that, Madam President?
Wouldn't
And
want
how
to guess.
long ago was that?
So which court would that be, my sisters? As a trial, it must be the trial court. So they would belong in the system.
Between the trial court and the appeal.
Really?
3 months.
That would be in a very utopian world.
My point.
With transcripts alone?
My
Very
point.
well, Mr. Fletcher.
A long time ago,
Exactly.
and rather surrealistic
But-
idea.
But the Privy Council stepped in and said we ought to let it go back to the time the sentence was imposed,
Yes.
to give the person the credit for what we call it, for the time spent.
Yes.
So that is how the Court of Appeal is doing it now. So had Mr. Moore been convicted, had his conviction been upheld, the court would have ordered at the time, on appeal, that he should start serving his sentence as of the date it was originally imposed, so he
Yes.
wouldn't suffer
Yes. But
any
it did-
detriment.
yes, Madam President, it did change from the 3 months,
Yes.
and I think an administrative decision was made. Well, let us just go right back
It
to
was a
the-
Privy Council in that case
Oh.
from Trinidad and
Okay.
Tobago that we followed.
Very well,
Yes.
very well.
All right, so we thank God where we are today. Things have moved along.
Yes.
So now you have problems with the judge's treatment of the matter?
The
No.
failure to give time spent in,
What's your ground? Just tell us what is your ground now, where it is.
it is,
Ground one. Is it solitary ground, is it?
hold on, man.
Sorry.
Hold on. It's not in here, you know. It's not in it. It's in the original. That ground is in the original filed because we consider this matter to be a continuation of that matter. This hearing today is an expansion and a continuation of the matter when it was filed first. So the ground, my Lady President, is in the original one in this bundle. Tab 2.
You see that
And-
paragraph 4? At 4?
Submission 6.
Oh, that is it?
Yes, ma'am.
Very well, thank you. So why the ground? Oh, so no, I'm trying to get it because when we look at your ground one, it says failed to adequately demonstrate and how he arrived at the sentencing. But then we see submissions now, he failed to give credit. That sounds like a second ground, really. Because I mean, it would be a part of one,
Yes, ma'am.
what you call your ground. But
Yes,
what you're
you're-
saying is your ground now is really
You're
not your ground.
completely correct, ma'am. This really ought to have been a second ground.
Because
But
if
we
he
thought-
I can appreciate that if you're saying he failed to give credit for the time spent in custody, you would have erred in failing to adequately demonstrate how he arrived.
Yes,
well,
my
the
Lady
sentence
President.
is different still from the
I think
credit
at the time,
anyway. Yes.
we thought that we could submit on the failure to give credit for the time spent in custody as part of the ground as stated there.
I see. So what you want as your ground now, let us be clear. The ground of appeal
the
being
failure.
pursued is
The sentence is manifestly excessive as far as this is manifestly excessive because of the failure to give credit for the time spent in pre-trial custody. And I will leave it there. I would not assume that the question that we're here to answer in relation to the constitutionality of something, that I can add this now. I'm just talking now about what we filed.
Mr. Fletcher, I'm sorry.
no, turn this on. Oh.
Mine is on. I'm a little confused and concerned because he had 2 trials And I just sat here and heard you say that on this second trial, he was on bail for the entire period. So what pre-trial period you are saying the judge failed to take into account? The pre-trial period on the first trial?
Yes, my lady. And between the first and second trial. Between the first and second trial.
Because his conviction was quashed and he...
Between the first and
Between
second
the first and second trial.
Yes.
So it's not whilst he was in custody on the first trial. No, it
No.
was between that period when the Court of Appeal sent him back for
Yes,
trial,
yes.
and he was in custody until his trial.
Yes, ma'am.
Very well. All right.
And when we came before the court the last time, the panel explicitly asked Mr. Wedderburn, who appeared for the DPP at that time, to research it in relation to that period.
Let me just to be clear, sorry, because we're... He was convicted in the first trial, and
Yes,
he appealed.
Yes, ma'am.
As far as the law is saying, when you appeal, when you file an appeal or application, time stops running for counting towards your sentence, but you are in custody
Yes,
so, on account of the sentence of the court.
Yes, ma'am.
So he was at GP,
Yes,
sent there from the first trial.
from the first trial.
The Court of Appeal did not uphold the conviction. The Court of Appeal quashed the conviction
Yes.
and set aside the sentence.
Yes, ma'am.
So he would have spent 2 years, more or less, and some more,
Yes.
at GP
Yes, ma'am.
while his appeal was being heard.
Yes.
And after the appeal was heard, he did not take up his bail immediately
Yes, ma'am.
until the appeal was dealt in 2014, and he took up his bail 2015.
March 2015. Yes.
So the issue before you call it pre-trial custody, and I think that is what is causing the confusion. But the question is, how does the court treat the period that the law called the dead years or the lost years,
Yes.
when he would have spent on a conviction that was ultimately set aside
Yes.
or quashed?
Yes.
So your argument is that, just like how Mr. Mellish said down below,
Yes.
take into account that this is a retrial, he would have served sentence on account of the first trial. How do you credit that?
Yes. And that was what the matter was brought, for arguments to be heard in relation to that. I think ultimately, my Lady Edwards, there's another time later on when that issue will come up.
What issue is that?
That the how to treat with that period. If I understand what
Which period? Because you see, this is a problem, and we have to be clear in hearing this case. What is it exactly we are hearing? Because it's a different question to ask, how should the court treat with time spent in custody, which we call pre-trial custody or remand time, whilst awaiting your trial? And should you be credited with that as part of your sentence? What it seems that we are dealing with here is the lost years, the period that we would, as my president said, the dead years, whilst you are in custody awaiting your appeal, in which the law says you are to be treated differently when you're in custody awaiting that period. Normally, and I stand to be corrected, that is not counted as credit for time spent in pretrial remand.
I don't think that's what we're asking for. It is the period of time between the appeal and the retrial.
Okay. So, all right. So we just want to be clear.
Yes, ma'am.
So what is it two? But we are mixed up because you counted 2 years and 9 months, and that would have been from 2012. Because what I understand the law to mean, Mr. Fletcher, what I understand it to mean is that if your conviction is quashed,
Yes, ma'am.
you go back as if you were never convicted. You are clothed again with the presumption of innocence,
Correct.
and every time we have had cases here where on a retrial from down below, the judge would look at how long you spent. I'm just saying that we have had cases like that, and give you credit for any time you spent in custody on account of the charge having been charged.
Yes, ma'am.
So your computation seems to me to mix us up because we thought and another reason why, which we expect to hear counsel help us on, is that you ought not to be sentenced to a higher sentence than you were on your first trial.
Yes, ma'am.
So now, the issue arose whether when he got 15 years, he spent more or less 2 years already. Is it that you are saying the court you must ignore the 2 years, you don't business about those 2 years? You have to let us know what you're talking about, because
Well,
we thought on your computation, you are saying that should be credited to him. The time spent on remand, still awaiting trial, because the Court of Appeal set aside whatever transpired in the first proceedings.
Very well, ma'am.
So you help us.
Here is what
All right.
I...
Before you
here-
start helping us, let us just demarcate the times, okay? So that people like me don't get confused, because we are having
My Lady Edwards.
separate principles.
My Lady Edwards,
Yes?
I'm sorry to stop here. You know
Yeah.
that I wouldn't do that
Yeah,
wantonly.
yeah.
I think it might be appropriate, since Madam President spoke about the wellness break,
So you can get your thoughts together.
that my learned junior can
Yeah, yeah.
help us.
All right. So just separate the periods for us. The
Yes.
period after the appeal
Yes.
and to the trial,
Yes, ma'am.
and the period was awaiting the appeal
Yes,
that my learned president has
I will
talked about.
provide the court with
Because
a
the
proper
principles
time
and the
and motion-
treatment of those periods are
time and
totally
motion
different. Yes.
chart.
Thank you.
Yes.
This is the 10 minutes break for you to, all of us, to get our breather. We come back at 10:34. 10:40. 4, 5. 10:45. By the time we open the door, it's 10:35.
Yes.
Thank you.
Very well.
Who first? You go, Sima, Pastor, please.
Sort it out. BPP. Time is not moving badly.
I hope you all stretched as we did. That is why the break was given, so you get up and stretch. Oh, you were stressed. Thank you. Mr. Fletcher, there's no need to be stressed out. Yes, you're ready for us now, based on the question asked?
I received instructions from my friend. He was arrested in June 2012. He was found guilty in November 2012 and sentenced in December 2012. And he was in custody all of that time. That is 6 months. He appealed, and that appeal
Was not heard for 2
was
years.
heard in December 2014.
And you would have appealed from 2012.
And he would have appealed from 2012.
Right,
And still in custody.
right.
And offered bail in December 2014, picked up bail in March 2015.
So your case is that he should be credited for?
Well, certainly for 6 months to begin with,
Yes.
that is the time from June to December. And I think I hear my lady Edward saying, and please, I know I do not run the risk of her not correcting me if I'm wrong. I think I hear her saying that the time between the sentence and appeal is not a part of our consideration, my lady.
Part of our consideration. I said the court considers it lost years, and are you putting those lost years as part of your appeal?
Yes, ma'am.
Okay.
Yes.
Awaiting
Yes.
appeal. No.
But you, yes, ma'am. And in fact,
You said 2 years and 9. You and the DPP agreed to 2-9.
yeah, that was the agreement. Yes, ma'am.
And that is why we had pitched it in the constitutional framework,
Yes,
because of this case is a bit different from the others that we have been dealing with over time in relation to pre-trial remand. We
Yes,
just
ma'am.
look at the period you're in custody up to the trial. In this case, he had a first
Yes.
trial, and the conviction was quashed.
Yes.
And then he was sentenced, like he was awaiting his appeal for roughly 2 years while at GP.
Yes, ma'am.
And then when he was sentenced now, no one took into account the periods he would have spent in custody,
Yes, ma'am.
because the court says that he was blocked. Well, he didn't really raise that at that point, but he said his hands are basically tied with the 15 years.
Yes, ma'am. And so in essence, this one is different because it was truncated.
Right. And there was two trials.
So it's
There were 2
truncated.
trials.
Yes.
All right. And the DPP, I think the court needs assistance eventually from them, because this case is puts another dimension to the appeal, in that the principle is that once you are retried, you ought not to get a sentence greater than what you had received on the first trial. So if he got 15 years on this, and you were to say spend 2 years already,
Yes.
how do you treat with that in the light of the authorities?
Of the authorities.
So that is, we understand, Mr. Fletcher. That's what I thought.
Yes, ma'am.
When I saw the period that you are talking about, I said you must be treating as lost years the time you would have served spent in custody, pending appeal, and all that, whether that should count towards the sentence that was imposed on him in the second trial.
Yes, ma'am.
Very well. I think we're all on the same page now.
I consider that exercise that we have done a very important part of the preliminaries.
That's why we get wellness break. It
Wellness break.
refocuses the brain.
Yes, sir.
Yes, so that having been said, so we're focusing now on whether the judge was wrong in law not to credit him
Yes,
for the time served in custody awaiting trial on this matter.
yes, ma'am.
And when we say awaiting trial, it means the second trial.
Yes, ma'am.
All right, so where are we now? Do we go to volume 2? Please? Sorry, stop.
Mine?
Give us 1 second, please, Mr. Fletcher. Let me tell you what we are doing, Mr. Fletcher. We are making sure that a formal order was made for you to abandon your original grounds and to rely on the supplementary grounds. So I'm checking if I could get the minute order there, Mr. James. Yes, we just want to ensure that all necessary orders are made before we move on. Mr. Fletcher, what we'll do to make sure that everything is in order is to I don't know if the DPP is opposing your application for leave to abandon your original grounds of appeal and to argue the supplementary ground as framed.
Only she can say that.
Yes.
We certainly will not be opposing that application.
Thank you very much.
May I say, milady, we have been telepathically feeling 900 friends stress.
You will bear it with him. Your shoulders are broad, it is said. Your back is broad, Miss Llewellyn. To abandon the original grounds of appeal. File. This one on the B1 form. This one is B1 form.
Mr. James.
Very well, Mr. Fletcher. The court will now make the formal order, the official order that leave is granted to the applicant to abandon the original grounds of appeal filed in the B1 form dated 31st March 2016, and to argue the supplementary ground of appeal as framed before this court, that the sentence is manifestly excessive because of failure of the learned trial judge to give credit for time spent in pre-trial custody or remand. Which one you want?
Remand.
So it will be on remand, on pre-trial remand.
Yes.
Very well, so that sets that. Thank you. So now we are ready for the submissions on the ground.
I hope the court,
Pre-trial remand. It has to be. 1 second. Did I not say? Yeah. Three. Was that not practically like? Yes, Mr. Fletcher, are you ready, or you're going to allow Mr. Other counsel, Sir Stewart?
I want to ask the court to just allow me just a little time, not much, to talk about how this matter of giving credit for time spent on remand came about, came into our jurisprudence. It appears that it came into our jurisprudence through the Privy Council case of Kalachan.
Just give the proper name. Remember, I have law students writing down, Mr. Fletcher.
I'm going to repeat it, my lady. Kalachand versus the state. Tab 6. And another.
It's Kachan and another
And anor.
against the state. It's Kalachan and another against the state, not Kalachan
Kalachand and
against the
another
state.
against
and
the
another.
state.
That's tab 6. And the citation is
2008 UKPC 49. It is at tab 6.
of volume 1.
Of volume 1.
Thank you.
Sir Paul Kennedy gave the judgment, and it was held. Any time spent in custody prior to sentencing should be taken fully into
Could you just
account.
direct us, sorry, page? Or the held your...
Yes, I'm reading from the head.
No, but we have there's no held in. Oh, thank you.
Should be taken fully into account, not simply by means of a form of words, but by means of an arithmetical deduction when assessing the length of the sentence that was to be served from the date of sentencing.
It would be good to at least, if you incorporate where a person was suspected, was taken into custody, because it is telling us from the time you're taken into custody until conviction is what should be looked at.
Yes, ma'am. Where a person was suspected of having committed an offense,
The commission. Yeah.
was taken into custody and was subsequently convicted, the sentence imposed should be the sentence which was appropriate for the offense. And then any time spent in custody after that. Yes. And to the best of my research, it is through this case that it found our way as a common law principle into our jurisprudence. Find Romeo da Costa Hall, please. Tab 7. The Privy Council restated the principle in Romeo da Costa Hall and the Queen.
You said the Privy Council.
The CCJ.
What you say is the same
You said the
difference?
Privy Council.
Caribbeanized. If I might take liberty with the language, the principle. It is at tab 7 of the bundle that you have. And its citation is 2011 CCJ 6 AJ in round brackets.
It's Romeo da Costa Hall.
Romeo da Costa Hall, DA space COSTA. So
Against
it's
the
really
Queen.
1, 2, 3, 4 names.
Yeah.
It's square brackets, Mr. Fletcher.
You say
Square brackets 2011, square brackets. And AJ in round brackets.
Yes.
Of course, it has been restated in Misha Clement.
That is what accepted it in our jurisprudence.
As at tab 8 of the volume that you have, volume 1. As part of,
Sorry, citation.
yes, minute. Square brackets 2016, JMCA, CRIM 26. It's our Court of Appeal case.
Yes.
Two of the justices of appeal who are sitting now
Side by side.
sat on that case. And the judgment was written by Justice Morrison.
A wave of sadness just came over me.
Pardon me? Waive
I
of
said a
sadness?
wave of sadness for
Yes,
the
ma'am.
mention of former President Morrison.
Yes, ma'am.
As he sat with us.
Yes.
Yes.
And it then found its way.
Sorry, just highlight the paragraph, Sir Clement, for me. You're going back to it? Just tell us where you're referring to. I think
What
it's
part of it
34.
you mean in the, what are you asking me for, Madam
I'm
President?
asking if you're referring to any paragraphs in the Misha Clement or
Not-
you're planning to go back to it.
I'm going back to it.
I see. You're just giving out an overview.
Yes, ma'am.
Thank you.
You got it. Find the paragraph. And then found its way into our very influential sentencing guidelines for use of the judges of the Supreme Court and parish courts. it's very interesting because I had a privilege, the great honor it was, to have sat on the Sentencing Guideline Committee. Justice Marva MacDonald, the Bishop, is recorded as another person who sat on that committee at that time.
Who is she?
Pardon me? She was there.
No, I just say, who is she?
Yes, ma'am.
It's okay.
I understand. And and the Office of the Director of Public Prosecutions was represented by Ms. Claudia Thompson. And with just a hint of a wave of sadness, Ms. Nancy Anderson was also on that committee. Well, lady, there was a day that you were unavoidably absent. Yes, ma'am. I remember it well.
Stays there.
And it was that day that the issue of putting in the giving credit for time spent in remand pre-trial was raised at the meeting and roundly opposed. One of the unforgettable moments of my life. Because with Miss Anderson, we asked for a break and found Kalachand and gave it to the committee.
I see.
And that sealed the idea. I mention it.
But was it already established in Misha Clement? Because Misha Clement was before the guidelines. So I'm not sure.
Should I put it this way? The spirit of giving credit for time spent in remand
Yes,
was not with us, notwithstanding the principle.
I see.
Yes. And it's an important thing, I think.
I found that a bit strange because Justice Morrison was the chairman of that committee.
Well,
he was the one who wrote
it
in
is he
Misha
suggested
Clement.
to us.
That's a principle
It
of
is
law.
he suggested to us that we go for the case.
Okay, let's see. Okay, based on where the opposition was coming
Yes.
from, I suppose.
Yes, and
We don't have to guess where.
Yes. Based on where the opposition was coming from.
Very well.
And we just took a break and we went and got the case.
Yes, I see.
Yes.
Thank you. So here we are today.
In paragraph 34 of Misha Clement, may I just read it, ma'am? He's speaking about sentencing and
But that is
mitigating factors.
Sorry, that is important for the DPP to hear in light of their submissions, because what the case sets out from 33 is how you arrive at your sentence.
Yes, ma'am.
And then how you treat with time served.
Yes, ma'am. So you'd like me to read both paragraphs, ma'am?
No, you don't have to read all of that. Just highlight that it sets up the principles
Yes, ma'am.
as to how to arrive at the appropriate sentence.
Yes.
Because the time served is not the sentence or part of the sentence.
Yes, ma'am. But I will read 34 if it pleases you,
Yeah.
ma'am. The list is now largely uncontroversial. However, in relation to time spent in custody before trial, we would add that it is now accepted that an offender should generally receive full credit and not some lesser discretionary discount for the time spent in custody pending trial. And he goes back to the authority of Kalachand and another versus the state, and then at 35 he mentions Romeo da Costa Hall versus the Queen, and so it's a part It's been a part, it's an active part. And at paragraph 56, my lady, you found paragraph 56, my lady? Members of the panel? Say Misha Clement. Just referring to how it's classified, says, turning now to mitigating factors, the judge considered correctly that the applicant should receive credit for time spent in custody pending trial. So it's applied, was applied. So that principle is a common law principle that has been in operation and well known in our jurisdiction. But, and may I just say this at this point, all of the variations and possibly the unevenness of the application of this principle coming along is probably due to the fact that judges have been grappling with its application as against the minimum sentence legislation.
I think it goes even further back than that.
Yes, ma'am.
They have been grappling with the application as to how to apply it.
Yes, ma'am.
Because it started in Romeo da Costa Hall.
Yes.
If you look, all the judges took different views as to how it was to be applied.
Yes.
So the question is whether it is part of your sentence,
Yes. But how do you apply it?
but how do you apply it?
Yes.
Is it a discount?
Yes.
Is it a mitigating factor?
Yes.
Or is a sentence that you have already served
Yes.
a part of?
That is right. And all of that comes from the Offense Against the Persons Act. And it's rigorous.
Yeah,
with the
because
minimum
the question, Mr. Fletcher, is the latter one that I mentioned. If it is a part of your sentence, then the question of minimum sentence is irrelevant. Because if you set a sentence of 15 years, that is the sentence. And if I say the time spent is to be credited as part of my sentence, and I've spent 3 years already, then the sentence still remains 15 years, it's just that I've spent 3 years already. Therefore, I only have 13 left. So it does not affect the minute. Oh, sorry.
My lady,
Can't count that. My math is terrible.
my lady Edwards,
12 left.
you have just raised a potent but nuanced point.
And that it's only nuanced because we have had this difficulty
Yes.
as to how to apply this credit.
That is right.
So I guess the question this panel will have to determine is which one of the approaches
Yes.
is best.
That is
Or
right. So I'm sure my friends here, but certainly I and my friend here are here maybe to raise some solutions that we think might be useful for consideration as quickly as we can. But I just wanted to make the point that I think that the conundrum in the evolution of the and the unevenness in its application comes from the minimum sentence.
Yeah. Because the rumor, none of the cases we have looked at, Kalachan didn't face that.
No.
I think it's only a case from Canada, the Woos case,
Yes.
that grappled with that.
Yes.
But as my sister said, it is only in Roma da Costa Hall that we have this, what seemed to be a struggle
Yes.
as to how to apply it and what you call it.
That is right.
Because eventually, Justice Witt said, it should be a part of the sentence. Taking as time served,
Yes.
the other judges were talking about, is it reduction of sentence or back dating? But there's a case from Trinidad and Tobago that we have. I don't know if you have it here.
Yes, ma'am.
Yes,
It's been given to me.
Gomes and right. And
Yes.
Privy Council just said, did the man spend 6 months in custody?
Yes.
Yes. Deduct it from the sentence,
Yes.
and the Privy Council said, the sentence now shall be
Yes.
12 months, minus the 6. So it takes us the same place. It amounts to, although the Canadian it says that a reduction in your sentence because you serve part of it. So to me, the best thing is to regard it as time served. But the CCJ was saying that Parliament should do that. So
Yes.
that is where the question is.
So we're still in a, we're still,
But they deducted it,
Yes.
But they still say whether it should be taken as time served.
That is
It's
right.
a matter for Parliament. But they gave the credit.
that is
so
right. And so we're still
Yes.
debating the provenance of,
Yes.
of what we can or ought to do. Now, what is interesting is that,
we have a
and my
case here
friend
that
from
so we
the
cannot do
Police
it.
Department and from the DPP will, I think it was Amir Hansen.
What's that, Mayor Hanson? Sorry, I think we might have jumped a little ahead of ourselves because what we have to confront is not only the grappling with how it interplays with the credit should interplay with the minimum, but we have a decision of this court.
Amir Hansen.
No, it's Erwin Harriet. Yes, so that's why we have to this case raises a question as to whether we reconsider our position.
Yes.
Right, so I think that case
Yes.
that you recall, Hanson followed Harriet. Yeah.
Yes. Yes, ma'am.
They all followed. I think Harriet was the first case from us,
Yes.
which says that we can't go below the statutory minimum.
ma'am.
And that is why the court has to assemble in the way it
Yes.
has
Yes, ma'am.
to determine should it continue on that path.
Yes, ma'am. And yes, ma'am. But into the mix for consideration is another problem, which is that failure to credit a person for time spent in pre-trial remand is unconstitutional. And violates Section 3. If the court will allow me to read it. 13.
13.
Yes, ma'am.
3.
3. Yes.
A.
Yes. The right to life, liberty, and security of the person, and the right not to be deprived thereof except in the execution of the sentence of a court in respect of a criminal offense of which the person has been convicted.
Conviction.
Pre-trial remand is not a conviction. It's just not.
I'm sorry, I didn't hear.
Pre-trial remand is not a conviction. That is
Oh.
that's self-evident. But for very practical, sociological purposes, the issue becomes even more poignant because
No, sorry, don't leave that yet, Mr. Fletcher. Isn't there another part of the Constitution that gives them the right to remand you on reasonable suspicion of having committed an offense, Mr. Stewart telling you? Because while it speaks of conviction under 13.3a, section, what is it, 13, or one of the due process, one of those provisions,
he's looking it up for me.
it does give them the right to remand you.
Yes.
on reasonable suspicion. But what we understand is that that now interplays with the presumption of innocence.
Yes, ma'am. That's another issue.
Yeah,
It's nuanced and it's another issue.
yeah.
We're
All right.
dealing here now with you're on remand awaiting a trial.
Yes.
And the thing about it is, from that sociological standpoint, is that the time that you spend on remand awaiting a trial is totally in the hands of the machinery of the state. It has nothing to do with the citizen. It is the state who's in total control of that. So you can spend 2, 3, 4 years just waiting. And obviously cannot be considered to have contributed in terms of the time. That is something that
Save
is
and
a
accept,
function. of the
Mr.
system.
Fletcher, when you have done something which contributes to the delay, and that has to be deducted from the time.
Yes, my lord.
Yes.
And in fact, the sentencing guidelines sets out the conditionalities very clearly.
So you're,
Exceptions to it. It sets it out.
so you're being asked to change from totally to usually,
Thank you, ma'am.
not totally.
Thank you, ma'am. And that change will
It's totally in the hands of the state.
run through the hands of your brothers and sisters, ma'am. My lady Shaw has asked to change to usually.
I think you had given a qualification. Yeah, it said the state in total control of it, and it cannot be said that it's you contributed to it.
Unless, of course,
Right, so
that
you
which is
did say
contained
that. Yes.
as those conditions set out in the.
Just a point, though, with Kalachand, as to the rationale for this. The Privy Council didn't really develop on it, and perhaps that's why Justice Witt, he went extensively in it and align it, and the CCJ, they seek to want to align it to your fundamental right. But the Privy Council did say that to give it is about your basic right to liberty.
Yes.
They didn't use the constitutional right to liberty, but the constitutional right is your basic right.
Yes.
So that is where it is coming from, and gives it this constitutional overtone because of what Kalachan says.
Yes, sir.
So, although you made the point about Section 13A, to be deprived, that is where it is emanating from, that they are saying the intrinsic value of liberty to the human being
Yes, ma'am.
is something that when the state deprives you of it, we have to carefully examine that.
Yes, ma'am.
That came from Kalachan, but other courts throughout the Caribbean, like in the Eastern Caribbean for one, have put it in the context of the Caribbean constitutions.
Yes.
So that is how it comes to be aligned with the Constitution
Yes, ma'am. That's why.
as your right to liberty.
That is why I've brought us, hopefully, to
Yes.
the point in the Constitution, specifically. And so, therefore, once we have reached there, the power of the legislation that introduces the mandatory minimum is weakened if it is in contradiction with a section of the Constitution. It's no longer a matter of a conflict between the common law principle and legislation.
We have to get that one.
I'm going too fast, man?
That's a powerful point you're making.
Well,
Yes, so you start out, I hope you can remember, the power of the legislation
You-
is
you-
being taken.
Madam President, you fed the power, but you didn't get the content.
Is weakened, because it comes in conflict, yes. And not a matter of the common law.
conflict between, just not a matter of just mere conflict between the common law and the legislation, but now, operationally, might be a conflict between the statute and our constitution. Well, if that is accepted, and that,
One second, please, Counsel. 1 second. I think so. Somebody misses what you said, and we have to get this right. It's potent.
Not a matter of mere conflict
between the common
And
law
the
and the legislation,
to say that Parliament's law should
yes,
override the common law.
which-
That is why we're here.
which has been stated over and over. We know that.
Exactly.
We know that. That is not new ground.
Exactly.
It's now a contrasting, comparative situation between the Constitution and the operations of a statute, an ordinary statute of Parliament. And my suggestion, my submission is that that is a game changer. It's not necessarily that we're going to make a submission that we should blast the legislation. Yes, and that friend Elon Musk can tell us and go up into the sky. No, but it certainly can affect what directions this court can give as to how the giving credit for time on remand is dealt with because of the importance of the Charter.
If we accept, and I think this is what we have to refine our thoughts based on your case, if we accept that being in pretrial custody engages your liberty rights, once the Constitution is engaged, then it now becomes a matter for the court to look at that engagement to see if the right of the individual, each individual, has to be considered, and if there's deprivation of liberty and the court finds that it is unjust for that deprivation to exist and to have existed, then the court, by virtue of its power as guardian of the Constitution and the people's rights, would use that to override Parliament, if not that you're troubling the statute itself, but the application of the minimum sentence.
And that is where
Grant a let us put it this way, my sisters are assisting me to refine our thoughts, because we have done it in the context of bail.
Yes.
Even if the statute says a convict must not get bail, the Court of Appeal, if it is shown that if we do not give you bail, your constitutional right to liberty will be infringed, then the court can grant bail despite the Bail Act as a constitutional remedy.
Yes, ma'am.
And that is what this case is focusing on.
Yes, ma'am.
Although it wasn't really clear from the
Yes.
question. The court has to deal with the question of having him in custody, spending 2 years before appeal. Then when he was retried, no allowance was made for that. Does that engage his constitutional rights?
Yes.
How do we treat that?
Yes, ma'am.
And can we use that to go below the minimum sentence
Yes,
by
ma'am.
giving an account of that?
And Duncan and Jokan
Duncan?
and Jacques Han versus the Attorney General of
Oh,
Trinidad
okay.
and Tobago.
Yeah, the court sent that to you for you to help us with because
Yes.
of the line of reasoning from the government side.
Yes.
We wanted to make sure they understand the point that the court is trying to make. The court is not saying that we're here to override Parliament.
Yes.
The court is here to determine whether it should give a constitutional remedy
Yes.
in the case where the person's constitutional right, if we so find,
Yes.
was engaged
And
and
the-
could be infringed.
And the court is simply
11:39.
restating in Jokan
Okay, so you're going to go to
about their
Dokan.
power. No, I'm going to
We
go to
have
the
it.
essence of what they're saying.
Yeah.
The court is restating their power to deal with reviewing
You acknowledge
matters
it is there.
where there has been a constitutional breach.
Breach. Thank you. A convenient point for us to
For
rise.
tea, ma'am?
We don't say for what.
Okay.
It's wellness break.
Well, let's. Very
And we
good.
join you to do.
Hold on, you chat
And,
so much, man. You all take
and we can consider too at the same time that the law is that. Oh. Yeah, give them out, please. Right. Right. We're not here about the constitutionality of the minimum sentence or anything.
No,
We're
no.
just here to see if Mr. Moore
Yes.
is to get his credit, and the Privy Council dealt with that
Yes,
in
ma'am.
Tafari Morris.
Thank you very much.
But even though it is there, the Privy Council accepts that the court can go below it if the sentence would amount to being an unjust and manifestly excessive.
Madam
sentence.
President,
Thank you.
I'm making the point that once we decide that there is a breach,
And there could be a breach.
there could be a breach. There's a fortification of the power of the court to deal with it
This was the case.
in a different way. We can continue after.
That's why we gave you this case.
Yes, ma'am.
Thank you. We rise now. Oh, you're not finished? Sorry. Yeah, we'll take the break now, and we return at 12:03.
Yeah, man, I'll let you.
We are in receipt of a bundle from the DPP's office now with authorities.
Yes, please.
We'll call that 4A,
Very well.
volume 4A for reference. Oh, they put that in there. Okay. Thank you. Yes, Mr. Fletcher, back at you.
Madam President, do you think that the time has come
That's a question.
when we ought to be given the opportunity to process all of this new information coming into us?
What is it? New information? I thought, is it newer than what came this morning? Remember, we had dealt with that at the opening.
New information.
Anyway, Mr. Fletcher, we deal with justice, rights, and fairness. So, as we ought to. So, at the end of it all, if we once we can give you time to get what the DPP has given you, and then you can prepare your reply, your response to them. And we told you that from this morning. We appreciate the position you're in. It ought not to be, and under normal circumstances, sometimes what we do is block late submissions. But to tell you the truth, when we are dealing with the liberty of the subject, and the court wishes for guidance in broad areas that will impact other cases, we'll be a bit more flexible in criminal matters. I must say.
Yes.
But we have our practice direction that establishes what the penalty is if you have late service. But this case is one of those that we will not penalize anyone today because of the nature of it, and the court has asked for assistance.
Yes, ma'am. I think the language we speak needs to change, and I think a word needs to be added to it. Response.
But to be fair to the
rather
DPP,
than response.
to be fair to the DPP this time though, ordinarily the DPP is all usually ready ahead of the appellants in this court. They oftentimes have to file documents before seeing what the appellants are saying, and then we have to give the appellant time to do what they have to do. So today the shoe just happened to be on the other foot. The appellants usually are the ones who are out of time. So for once, Mr. Fletcher, we have this case, and I think all credit would be due to Mr. Stewart as instructing counsel. Or we should give you some of it. All right, we give you some of it. One second. So my sisters and brothers are asking me to ask you. You can ask him too, you know. You can go ahead and ask him. Thank you. I don't know why
Fletcher,
they think I
we're
should
saying,
speak.
what is it that you really want at this point? Because you came in with that question. What is it that you would really want at this point?
I'm wondering that, bearing in mind new documents being served, do any of these actually affect my potential present submissions? I don't know. I haven't had a chance to process them. So when your leadership speaks to me about a reply,
Sorry. I think what we said this morning stands unmodified. We say, proceed as if you have not received anything from the DPP because you are the applicant.
Yes.
You brought the appeal, you do your thing.
Yes.
When they respond, and what you will get that opportunity, and we said it this morning, for your reply, and
Very
you're
well.
permitted to reply to everything.
very well, ma'am.
And guess what? Tomorrow we might have to just commence a little later than this morning because I have an involvement in a meeting that has to go on.
Yes.
So at 8 o'clock with the hope that we finish at 9. But in any event, we could give you even 10 o'clock to start. You'll get additional time. But these are authorities that we're seeing coming in. And the court usually doesn't really turn its back on authorities. These that we got just a while ago. And I think it's the one that they brought this morning, but it's now put in a bundle. Anyway, don't waste any more time, Mr. Fletcher. Time is precious. You're on your feet. Do your appeal do your appeal. And then whatever happens, we will give you time to respond to the late documents. That's what we said this morning.
I'm always in your hands.
Thank you. But now that the DPP is seeing the response, I'm sure it will not happen again. Thank you. Go ahead.
When we left, I think I was moving gently from the point that if it is accepted that failure to give the time spent on remand back, credit the time spent on remand back, if it is accepted that that is a breach of that section of the Charter of Rights, that is a game changer. Because it is no longer a matter of a contest or conflict between a common law principle and legislation out of Parliament that sets up the minimum sentence and precludes some judges from applying the credit for time spent on remand. It's no longer that. It is now an issue of the operationalizing of a piece of legislation that brings things into conflict with a constitutional provision. Different hierarchy, different ladder. And so in a sense, many of the cases that have been discussed and decided as our judiciary try to grapple with the conundrum are just, they are what they are. They try to grapple with the conundrum. Now we are in a different paradigm.
When you say they try to grapple with the conundrum, you have to say what specific conundrum they were grappling with.
Yes, I'm going to say that.
Okay, then. You're talking about the previous cases? Or
Yes,
you?
ma'am.
Okay.
Well, my lady, could you indulge me and turn to paragraph 8 and 9 of my written submissions in compliance with case management directions, volume 2. Where is it? No, it's not in here. Wait there. But what are you telling me about volume 2? Volume 2, yes, okay. Okay. The paragraph 9 in particular. I'm going to read it. It's entitled The Systemic Tension. The systemic tension. It is not unreasonable to see.
We have a different pronunciation, so we say systemic. Is that what you... Safe.
And what was my pronunciation?
A long E sound.
I said systemic.
Yes.
And you say systemic.
Well, maybe we are wrong, but we just want to be clear that
I'm always in your hands.
Well, there certainly is tension.
Pardon?
There's tension. At least in the pronunciation.
we couldn't find out error said. I was looking for steam. STEAM. Yes.
Yes.
Very well.
This is systemic tension.
Yes.
Yes. It is not unreasonable to see that there is an apparent and inevitable tension between mandatory sentences and the traditional separation between the legislature and the courts. These mandatory sentences are a clear fetter on the power of courts to adjust sentences to meet the particular circumstances of the case before them. And the citizen introduced section 42K and 42L. In the former, that is 42K, if the sentencing judge is of the belief that the mandatory minimum is manifestly excessive and unjust in the circumstances of the case, the sentencing judge will issue a certificate which allows the applicant to petition the Court of Appeal ultimately to review the sentence punishable. I'm beginning to sense within my own self that we're ultimately going to end up with a power residing in the Court of Appeal to solve this problem. May I continue?
What's the problem though? I'm not so clear.
The tension.
Are you saying that if this is how
Saying that if this is how it is resolved, then many cases would come up here? Is that what you're saying?
Yes, ma'am.
Oh,
I'm saying that maybe one of the solutions that we will eventually end up with
Yes.
is the Court of Appeal having the power, because now the tension is between the minimum sentence legislation and the Constitution. The Court of Appeal now has the inherent power to review all sentences that are manifestly excessive and all where time is not given for the time spent on remand. Because the Court of Appeal has that power.
The absence of a certificate, because you raised a certificate point, so that's why I wanted you to fit it in.
Yes, ma'am. The Court of Appeal, in my view, has an inherent authority to deal with. Well, may I just go to one of the cases then?
Make your point first, because you raised 42K and L, and we just
Yes,
want
42K and L.
to say
My
what
point
you're
is
saying.
that
In
the-
this case, sorry, you're saying 42K requires the sentencing judge to issue a certificate if he believes or she believes that the mandatory minimum is would be manifestly excessive
And
and
to
unjust.
state-
Yes?
and to state the
Reasons.
reasons
Yes.
why the mandatory minimum sentence is manifestly excessive.
Yeah, I just want to get the
Yes.
point. Yes. And then you went on, just to finish your submission and you take us to the case.
Yes.
You went over leave to tell us now, suppose the sentencing judge failed to issue that certificate and the case, the sentence could well be manifestly
Yes.
excessive.
I'm
You
saying
have
that
it on the next page.
because, that's why I used the phrase game changer,
Yeah.
because now We are looking at a breach of a citizen's constitutional right. The Court of Appeal can review that sentence in those terms.
Unfortunately, I'm not really following, Mr. Fletcher.
Yes, ma'am.
Are you saying that this Court of Appeal would review even if there's no certificate in order to grant constitutional relief? So all of them, every case where there's a mandatory minimum imposed, regardless of whether there's a certificate, they would have to come up here for this court to then grant constitutional redress by way of giving credit. That's what you're saying?
So why the court? Why, if you are saying this, the Court of Appeal should fix it, and bearing in mind that what the Court of Appeal says binds the lower court until set aside by a higher court. If the court believes that to give effect to the constitutional right when a person is deprived of his liberty, and you do not give them the credit for the time served, why the court can't say in its judgment, if it believes that the court down below should do so, and then it would avoid, I'm just asking, avoiding this the multiplicity of appeals for persons who can't even afford appeals. You're talking about the pressure on the public purse to give legal aid, as we have to do in this case. If the Court of Appeal believes that the constitutional right should be given effect to, then the court can say when a person, any court can, I don't see why the Supreme Court, and the Supreme Court is also the guardian of the Constitution. That's the guardian of the Constitution. Why they can't give it? We can say give it. Why we can't do that? It's a lot of work for us, for everybody to come up here and us for that. Because that is why we're sitting today. If we agree with you that we should give effect to that right and reduce and credit the person for time served, we just direct that ought to be done as of now.
My lady, post abusing. Thank you for the observation. Because what it actually reminds me is that I put the cart before the horse. What my lady president has just reminded me of is something I was going to go on to next. What I'm placing is the repository of the ultimate power to do the review with you. And I would expect that in a judgment, if, for example, this court is taking a certain position, that judgment would direct that down there, right there at trial, right there, you're expected
Mr. Fletcher,
to give the relief.
Counsel, that is why I thought that when you announced that this decision
Yes.
was a game changer,
Yes.
I thought you meant the way forward.
Well,
As of now,
let me upend
this
it then,
game
ma'am.
changer
Yes, ma'am.
will dictate what is to be done.
That is right.
henceforth.
That is right.
So for you to now be telling us that we now have to deal, it sounded as if, as my sister seemed to have understood it, we were going to just get a flood, the floodgate, that famous floodgate. Come Court of Appeal for redress. The game-changing
Yes.
pronunciation in
Yes.
this matter will
Yes, ma'am.
determine the way forward
Yes,
for
ma'am.
all courts.
Yes, ma'am.
If
That-
we agree with you.
If you agree with me,
Yeah.
that
Well, for
is the
those, it's
point.
still a game changer.
And I think
Exactly.
where I may have misstepped, because what I did was alert the sensitivities to the workload. Yes.
I think you're moving on to mention 42K.
Yes,
What
ma'am.
took us into another realm.
Right, ma'am.
Complete the realm
Yes, ma'am.
before we decide whether we need to go into the details.
Right. So let me just, for my own sake at least, just remind one, directions to the court. apply the thing. But what happens as could happen if it's not applied? This court will have to apply it.
I'm going to save you, Mr. Fletcher, unless what you meant was if somehow the directions are given and one or two or several judges don't follow the direction, then we will still have the workload and the repository will still remain with us.
Yes.
Ultimately.
Best word, ma'am, repository. Yes, repository. And what my lady, president, was reacting to is that you have used the word repository. She was reacting to the idea of the depository of all of these appeals all of a sudden on the court. Yes.
Remember, as I said this morning in opening, we're dealing with the gun court jurisdiction,
Yes.
which is unique.
Yes.
I don't know of any other country in the Caribbean with a gun court. And Parliament, in its wisdom, saw it fit to make us the final court
Yes.
in matters dealing with the High Court division.
Yes.
So that's why we have to be careful what we do.
Yes.
And whatever we do will forever bind
Yes.
down below because there's no higher place
Yes.
to go in that. So that's why we call for all the help we need
Yes.
to ensure that we get it right or try to get it right.
Well,
Because you mentioned Irwin Harriet around there, which this court had said you just cannot go below the minimum no
Yes,
matter
ma'am.
what.
Yes, and there are some other authorities that I think Amir Hansen.
All right, so take us there now. We get your point now. I think we're clear. We're clear as to what you're saying. What is you sending up new things on us too? Are you complaining?
No, ma'am. What I'm giving Mr. James is a repository.
To deposit.
Oh dear, poor
Give me back
us.
one of that, Mr. James. No, well,
Our work will
to
never
no avail,
end.
because
What is that you're passing up to us?
no, ma'am. I'm just giving him for the time being. This just goes with Harriet and so on. This is one way. This court, Justice Leng acting, made the point that we couldn't go in certain circumstances. We couldn't go below.
We could go, yes, that was given.
Yes,
It was a given.
Yes. But that
They have created a little gateway outside of the minimum
yes,
to say if the judge intended to give a certificate or something.
yes,
They put it on the certificate,
yes.
but we are not stuck on the certificate. Yes, that is what the court has done, devised a mechanism, it seems. All right,
So K requires a certificate,
yes.
and so we're talking about the court making a direction, but the question that I have in my mind, and I must be very honest with the court, it is not, as a matter of logistics, it is not resolved in my mind. The idea that another option could be that the certificate, because it's very possible that a judge is at odds with his or herself in relation to applying the minimum and the time spent in remand. Give a certificate to the Court of Appeal to say, could you resolve it to me? For me, it's almost like case stated. Almost like that. That's another option.
I think a problem too that we have to deal with is that judges tend to conflate the sentence, and not only judges, with the time to be credited. And I think the DPP has done it in their DPP's office in their submissions. They are saying the sentence is lenient already, so therefore then But based on the law, it is an entitlement, and you reach there after the sentence is arrived at by using the principles of sentencing. So, and that is how, when you look at your case from Canada, how they treat with it, because the sentence is already arrived at. 42K is about whether that sentence is unjust and disproportionate, and then you go on to give the time, credit for time served. So that's another thing that we have to examine. Judges might say, oh, the 15 is enough, that's it. But that is before you arrive at how the methodology sets it out. You have to give credit after you give the you declare the sentence.
Yes. And in addition to that, of course, Madam President, you would expect that we probably discussed this with other counts. And it's interesting that somebody said, well, is it possible that a sentence could go unreasonably high to take care of the time spent in custody so that it would come down to the mean?
That can happen too, but the question is that is open to review because it's a transparent process.
Yes.
Through the methodology that you have to apply.
Yes.
So we have to see a starting point, we have to
Yes.
see your aggravating and mitigating and balancing and stuff.
Yes.
So if you arrive, we have to ensure the starting point you choose to begin with is not high and unreasonable.
Yes.
So these are issues that the court will have to address. But what we're dealing with today is having arrived at that sentence, your first ground would have taken account of that, the first ground that you had,
Yes.
about the judge failing to demonstrate.
Yes.
But he couldn't go any lower than 15 years in terms of the sentence,
Yes.
because of the statutory minimum.
Yes.
So you couldn't complain. The issue is, having arrived at the sentence, what do you do with the time the man served in pre-sentence custody? That's it.
Yes.
Because what you do, if he spent let us say he had spent 4 years there, awaiting trial, you're still saying we can't take it out, and although 15 years is what this offense and offender would warrant, you'd end up with 19 years
Yes.
in prison, in custody.
Yes.
The issue arises, is the sentence rendered unjust?
Yes.
Because when you look at Justice Witt's reasoning in Romeo da Costa
Romeo da
Hall,
Costa Hall,
they say it's a bare question of justice and fairness, and the Privy Council say right to liberty.
Yes.
So these are the things we have to consider. So you're right, a judge could want to take care of that by inflating the sentence. So when they take off the time, you drop there, but that is susceptible to review.
Yes. Separately.
Separately. So anyway, we can move on. Help us out with your authorities now. You were telling us about K and about 42K. And we are looking back at your submissions.
Yes. And in
Where
that
say, for example, you asked a question, is a citizen's constitutional right to liberty encroached upon in a case of a mandatory minimum offense where the sentencing judge fails to issue a certificate, as you would say in this case, or fails to indicate a desire to go below the mandatory minimum?
Yes.
And you refer to cases there.
We're not school day.
Was that the case?
You in Harriet.
And does not get credit. So I think we understand our jurisprudence, how it has developed.
Yes.
Help us out with the Canadians court now consideration, which is paragraph 11.
Yes.
Bearing in mind you have only 26 minutes left for the day, and you don't have all day tomorrow. Thank you.
Well, I'll stop now.
Stop where? Stop where? No, you have 20. I'm just telling you where you how much time we have left for the day. So just go on to paragraph 11.
1 o'clock. Yes.
Yeah, to 1 o'clock.
Okay.
Yeah.
The Canadians have grappled with this problem. And I think that one of the just a minute. Is it camera? Who supplied McDonald? That's another case.
When you talk about but we don't look at us yet.
No, but I think it is very important.
Or to look at McDonald's
if it
first?
pleases you to
Okay.
just know the time and motion development
I see.
of that. And one of the things that eventually happened is that this concept of the time served has raised its head. That concept is that of course you can have your minimum sentence, but it appears that you might have the power to decide when the sentence should run, from when the sentence should run, and do you have the power to make the sentence, the term of imprisonment, run from the time of arrest?
That's what they call backdating.
Backdating.
But that was rejected by the CCJ. But the Privy Council didn't go down, so didn't get so far.
No.
Privy Council sent it back to Mauritius
Yes.
for them to deal with that.
Yes. I think that, and I submit that at first blush, it's a little radical, and we're unused to it. But I submit it to the court as an option. Yes.
Mr. Fletcher,
Yes,
we
ma'am.
have cases from the Privy Council. Where what the Privy Council did, I think, with Gomes' case, is just to minus it from the deduct it from the sentence and declare that the man must serve the remaining time.
Yes, ma'am.
And if we are going to follow anybody else in anything, we will have to view that as the most persuasive
Yes, ma'am.
authority there is.
Yes, ma'am.
To
And what
say
I-
if there's a case from here that goes there, that is what
Yes,
the
ma'am.
Privy Council do. Just simply deduct it and say the man is to serve
Yes, ma'am.
the rest.
Well, I raised that, ma'am, because I think that's a real option.
The backdating is a bit technical and might demand
And it sounds,
statutory intervention.
I guess it sounds exotic. Yes. We could find another name for it. But I appreciate that.
We don't judge it. Is it later? Well,
My lady,
as long as
members
it's
of the
in custody.
panel,
Yeah, go ahead.
I would like to stop now,
Pardon?
with your permission,
What is wrong with it?
and come back tomorrow morning very briefly.
Because you wanted to just highlight where in the cases you want us, the cases that you have cited, just lead us, highlight the sections that you want us to
I know what you want, but I'm making a request of the court.
It's all right, we'll leave it with you.
And Mr. Fletcher, in the context of Boost, which was decided based on a provision in the Criminal Code of Canada
Yes.
that gave judges the power to consider, to apply time served. So there was that provision, and then came section 3344A, I believe, that introduced the mandatory minimum for armed robbery with a firearm. And so they were looking at the case
the problem in that context,
Yes.
and also applying, of course, charter principles.
Yes.
But ultimately found that the mandatory minimum sentence was not unconstitutional,
Yes.
and found that Section 7193 did give the court the power to go below
Yes.
the mandatory minimum.
I'll be very brief tomorrow morning.
Okay.
And I will take
So-
all of that into account.
Okay. We don't have such a provision, of course, in Jamaica.
Jamaica.
We are using the common
common
law.
law.
Yes.
And that is the point you have raised now,
Yes.
to say that it is beyond just the common law,
Yes.
because we are grappling
We are
with
grappling with the
constitutional
constitutional
principles,
issue.
the right to liberty,
Right.
as we understand.
Yes.
Thank you. I think we're much clearer today. All of us should be on the same footing as to what the court is getting at by sitting in the full court. It's and I'm happy that we have managed to ventilate what the core of our problem is that we're grappling with as a jurisdiction,
Yes. Yes.
because Parliament has failed to provide that guidance in the
Yes.
legislation like some other
Yes.
places. So
Yes.
I hope the Crown will be able to see exactly what we need assistance on much clearer. It's not
Yes.
about common law versus the statute,
Yes.
but how the court should move to give effect to the supreme law, which is the Constitution.
It's a constitution.
All right, as I've indicated earlier, I have a difficulty for 9:30 in the morning. I think 10 o'clock, or I think 10:30 is safer.
Yeah.
10:30 is safer for us to commence, and that will give you enough time, Mr. Fletcher, to review what you have been handed by the DPP,
Yes, ma'am.
to see if what you have been given will affect your
Yes,
core presentation.
Thank you very
And
much.
we will not be taking any additional papers except a decision, perhaps an authority that would just help us to just decide the case now and
I hope
stop.
not. I hope not. to
That's
get
what
into
we're
such
looking for. If we get that authority, we'll take it. We're looking for a game changer for the work of the court. Thank you. All right, thank you, Madam DPP. I trust we'll have no other presents tomorrow morning. We are logging out of gifts.
And if I may say, lady, we are very grateful for how the arguments now have been listed, because we on this side were not quite clear on the government side.
I suspect
But
so.
I think this will make our submission shorter and much more.
Thank you. I know you'd see that. Thank you very much. So thank you for your indulgence for allowing me a little extra time in the morning. It is government's business I'm going on. Let me declare it publicly. I'm dealing with government's business in the morning. Or the court's business in the morning. And so we'll commence at 10:30 sharp. Thank you very much. Have a good day.
Please stand. This honor court now adjourned to tomorrow at 10:30 a.m.
These are yours, Jeff.
Yes. That there were